LB265 does directly impact the Foster Care Review Office and makes some substantial changes to our statutes. LB265 takes effect on August 29th of 2015, so we do have some time periods in which to work some of these processes out. The first thing it does that directly impacts our office is that it gives us authority to participate in proceedings involving youth placed on probation, so that would be delinquent and status offense youth. And it also states that for these probation youth, our written findings and recommendations shall be admissible in court as long as we've provided documents to all other parties of record. So beginning as of September 1st, we will start reviewing probation and status offense cases for any youth placed in out-of-home care. There's also some specific changes to the Foster Care Review Office statute. The first thing that it did is it defines and clarifies the definition of what is a foster care placement. It basically is all type of placements of youth in out-of-home care defined under 43-245 and 43-247. So it is any reason that a youth is adjudicated in juvenile court. It also defines foster care placement as all types of placement for neglected, dependent, or delinquent children, including those placed by Health and Human Services, by the courts, by parents, or by third parties. It includes children that have been voluntarily relinquished to the Department of Health and Human Services or a child placing agency. It also now includes all types of placements that are considered to be trial home visits. The statute goes on to define what is a trial home visit. A trial home visit involves any court-involved juvenile who goes from a foster care placement back to their parents' home but remains a ward of the state. This is a very large change for the Foster Care Review Office because now it gives us authority to review cases for children that were placed out of home but are now placed home. Part of the reasons that senators gave wanting this change was to ensure that when those youth go home, those children go home, that appropriate services are being given while they're in the home, so in order to decrease our reentry rate into out-of-home care. So starting September 1st, we will be looking at children that are placed at home if they have previously been in out-of-home care. LB265 also clarifies that the Office of Probation must report information to the Foster Care Review Office, just like the Department of Health and Human Services does, for every youth that is placed in out-of-home care. It also grants us access to all probation information and records upon a court order. What this means is that before we can review any probation case, we do need to obtain an order from the judge granting us access to all of this information. We have been working with probation and will continue to work with probation over the next 3 months in developing a very clear process as to how those court orders will be obtained so that we can review probation youth. There were changes under LB265 with regards to the appointment of our advisory committee. These now are appointed by the governor and confirmed by the Health and Human Service Committee and the legislature. It's still made up of 3 local board members, a data analysis person, and a public at large representative. The other change that LB265 does is that it requires that all foster care placements, whether by probation or Health and Human Services, must be reported to us on a weekly basis instead of a monthly basis. Any changes in placements must be reported within 3 days. What this allows us to do is to ensure that our records are up to date as to the information and placement of that child. For local board members, this bill did some significant changes to our local board meetings. Under LB265, there now is a provision in the law that says due to the confidential nature of our local board meetings, the portion of our meeting that discusses information, this confidential information, which means our entire meeting, shall be exempt from the open meetings law. So starting on September 1st, we will not have to do the open meetings exception and provisions for our local board meetings. I know many of you have expressed that wish in the past 2 years that we do, and we're able to do that, so this bill does take care of that. Another important provision that happened that directly affects us is there is now a statement in the statute that says our final recommendations and findings report that are submitted to the court from our local boards shall be admissible in court as long as we've provided copies to all other parties of record. So now that we have the ability to ensure that our documents are getting to the judge and that the judge is admitting them into evidence. Another change that was done is that the senators have expressed a lot of confidence in the Foster Care Review Office and in our data and in our process. So they added a provision to the law now that states that at the request of any other state agency, the Foster Care Review Office can conduct a file review process and data analysis regarding any state ward or ward of the court, whether they're in-home or out-of-home at the time of the case file review. What this allows us to do is to expand our data analysis and research ability working with both probation and HHS. The last thing that LB265 does is it creates an out-of-home data pilot project. And under this, the Foster Care Review Office is to administer this pilot at the direction of the Out-of-Home Data Pilot Project Advisory Group, whose membership is set by statute. The whole purpose of this pilot is to demonstrate how an existing state agency's data system that is currently being used could serve as a foundation for an independent external oversight data warehouse. There are specific people that make up the advisory group. We, of course, are a member of this advisory group. This pilot terminates on January 1st of 2017. This group is to have a report available by December 15th of 2015. But the whole purpose of this group is to really look into the creation of a data warehouse where all the other types of data systems would put their information together so that we would have a much clearer picture as to how Johnny would be doing in the Department of Education, within Health and Human Services, within probation, and with any other system that might be involved with Johnny, such as the Crime Commission. We do not know what this warehouse would look like. This is the beginning first steps of it. The senators really want this group to look at how we would account for children and juveniles in out-of-home care regardless of how they entered, to determine whether placement outcomes for children meet policy goals for children, to really figure out if children are better off as a result of placement, and to come up with indicators as to what would be a successful placement. One of the questions, I will give you an example that we as an agency have struggled with, and we feel this is a direction to go through this warehouse pilot, is trying to figure out whether the longer a child is in out-of-home care, does it decrease their chance of reentry into the system, or does it increase their chance of reentry into the system? Those are some very important questions that directly impact all of the work that we do as we review case files and determine what is really in the best interest of the child. So we are very excited about this data warehouse pilot to see what direction it will go and what the future directions are. One of the things that we have done as an agency in preparation for LB265 is we are currently in the process of creating a new database for ourselves. The database that we had been using is over 20 years old and has not been updated. We are hoping by July 1st that we will have a new database created on an SQL database that would then allow us to go into this data warehouse and be able to accumulate the other relevant information that we need with regards to these children. So it's an exciting time for the Foster Care Review Office as we go forward under LB265, looking at probation cases, looking at trial home visit cases, and then also looking at the data warehouse. We will keep you informed as these processes are developed. We do hope to have something in place by the end of August of 2015. So keep watching and we will keep you informed as to where we are going next.